Welcome back from lunch. I hope everyone had a nice break. We are resuming the Board of Behavioral Sciences meeting, and it's August 18th, 2023. We are resuming with agenda item number 19, Telehealth Committee update. Roseanne, the floor is yours.
Thanks, Chris. So our telehealth committee had its most recent meeting this past June 8th. And the telehealth committee, we've had this committee for a couple of years. It's kind of in the process of winding down now. We've tackled a lot of the topics over the past couple of years that were the board's goals. And the purpose was really to see if any of the regulations and laws related to the practice of telehealth needed to be updated or clarified. And we've done several updates and clarifications now. At the last committee meeting, the board and stakeholders reviewed the results of a board survey to gather information about licensee and registered experiences working for online-only therapy platforms. And so the committee directed staff to meet with the Senate Business and Professions Committees and the Assembly Business and Professions Committee to discuss some of the concerns with the survey results and then draft a potential letter to online-only therapy platforms. So we'll be reporting back on that at the next meeting on September 7th. And then also discussed at that meeting were the current efforts in other states to develop interstate compacts for social work and counselors. And so the next meeting on September 7th will be continuing with a few discussions on the online-only therapy platforms, and then taking a look at the telehealth regulations to see if the committee feels that any final updates are needed. So that's the telehealth committee status.
Thank you, Roseanne. Are there any comments or questions from our board members? Any comments or questions from the audience? All right, how about from our remote audience? Moderator, would you please open the lines?
We've opened up the WebEx Q&A and hand raise features to facilitate public comments. If you'd like to make a comment, you may click on the hand icon to raise your hand. You may look for the question mark icon, click that, type the word comment and click send, or our call-in users can press *3 to raise their hand. Each speaker will have 2 minutes to speak with a 15-second warning. Are there any comments on the committee report? I do not see any requests for comment. Shall I close that feature?
Yes, thank you.
You're welcome.
All right, next item on the agenda is the licensing committee update. Roseanne, it's all yours.
Thanks. So the licensing committee held its last meeting on July 21st. The board formed the licensing committee to conduct an in-depth discussion about several topics related to the licensing process. We've done some discussions on that regarding the law and ethics exam so far. At this past meeting, the committee discussed short and long-term goals for its workforce development action plan, which is going through that committee. That action plan consisted of 3 main efforts: data analysis, reducing barriers to licensure, and recruitment and retention. And at that last meeting, the committee also reviewed a draft of a consumer outreach document designed to explain the board's regulated professions to the public, which will be looking at the next committee meeting at a revised version of that. And then, as we mentioned earlier, there will be some discussion related to the exam as we move that committee forward. The next meeting is going to be held on October, Steve, I believe it's the 13th. Is that correct?
Yes, that's what we have.
October 13th, yes.
Thank you, Roseanne. Any comments or questions from the board? From our audience? How about our remote audience?
We are open for questions or requests for comment on the licensing committee update. If you'd like to make a comment, you may click the hand icon to raise your hand, or you may click the question mark icon, type the word comment and click send. And our call-in users may press *3 to raise their hand. Are there any comments on the licensing committee report? I see no requests for comment. Shall I close that feature?
Yes, thank you.
You're welcome.
Mr. Chair,
Yes, Dr.
could you
Walker.
circle back? I have a question.
Sure, absolutely.
Thank you so much. I note that our next licensing committee meeting in the memo is October 12th, but so is that
I have to clarify, originally it was October 13th. I'm going to confirm that with all the committee members again but October 13th was the original date. I think I might have made a mistake on the October 12th on the actually
Got it. Okay.
meetings. So we will
Okay.
be confirming that.
Thank
So.
you.
Thank you. Thanks for catching that. All right, next, there we go. Next on the agenda is the discussion and possible action regarding AB 665 from CREO, minors consent to mental health services. Roseanne?
Yeah, thanks, Chris. So we have several bills to discuss today that have been substantially amended since the board last took positions on them in May. So the purpose of bringing these bills back is to make the board aware of the substantive changes that have happened to these bills and have the board either decide to reaffirm or change its positions as these bills continue to move forward. So the first one up today is AB 665, and that has to do with minors and consent to mental health services. And we discussed this bill in May. It seeks to make the requirements for a minor to consent to mental health treatment equal for both Medi-Cal recipients and non-Medi-Cal recipients. Currently, there are 2 consent provisions in various places in California law. One of them applies to Medi-Cal recipients only, and then the other one in Health and Safety Code applies to everyone else. So the proposed changes being made today in this bill are for the Family Code Section 6924, which apply to Medi-Cal recipients. And those changes have historically been they're a higher level than the current other required consent for everybody else. So the author is seeking to make the consent requirements more equitable, so those minors on Medi-Cal don't have to meet a higher threshold to consent to mental health services. So what this bill does specifically is it amends the definition of a professional person for purposes of the bill for consent for Medi-Cal recipients. So it is the same as the definition in the Health and Safety Code, which applies to everybody else. It removes the minor consent requirements for minors on Medi-Cal that in order to be able to consent, the minor must either be the alleged victim of incest or child abuse or would present a danger or serious physical or mental health harm to self or others. And it removes the requirement that the parent or guardian must be included in the treatment of minor unless, in the opinion of the professional person treating the minor, involvement would be inappropriate. Instead, it requires the parent or guardian be included unless the professional person treating the minor, after consulting with the minor, determines that the involvement would be inappropriate. Previously, at its May meeting, the board had taken a support position on this bill in its previous form. But in addition to its support position, the board provided the author with certain feedback. The board requested that the author consider amending the term professional person in the Family Code to match the one in the Health and Safety Code so that all of the board's license types, associate registrations, and pre-degree practicum students have the same standards for minor consent, whether using Medi-Cal or not. So it'd be the same professionals that can be used. Right now, there is a discrepancy. And so the author has, per the board's request, made that particular change in the most recent amendments. We also asked the author's office to consider correcting an incorrect reference to LEP statute, and the author has made that change as well. The board also asked, it raised a question at that meeting regarding how the bill might interact with certain welfare and institution code sections 16001.9 and 361.5 with parental consent in a foster child reunification case if there was a court order, and whether or not adding a subdivision to address this would be beneficial. So I met with the sponsors, including one of the sponsors' attorneys, who's very well versed in this subject, and they noted that there's not an actual conflict here. However, they felt that feedback was very helpful because they believe a FAQ, if the bill is passed, to provide some clarification regarding this might be helpful for them to distribute. So that's where we ended up with that. And so the current version of the bill is before you today for your consideration and discussion. Thanks.
Thank you, Roseanne. Any comments or discussion from the board? Kelly?
I just thank Roseanne for all of her work on this bill. It looks really good.
Oh, he thanked Roseanne for all of her hard work.
I was just thanking Roseanne for all of her analysis and hard work.
Susan?
Roseanne, I just have a really quick question. And I mean, this is a wonderful idea, but do they ever talk about where they're going to get these therapists, these mental health counselors? Are they going to manufacture them?
So this is, subject of the bill is for how a therapist can consent to treating a minor. If a minor comes to them and wants therapy, they have to meet, and without their parent, they have to meet certain thresholds. So it's not really a therapist pipeline bill. It has to do just with consent.
Okay, thanks.
First of all, sorry, Abigail. Thank you, Rosanna. Again, I would like to reiterate that we know there is a lot of work in the conversation behind the scene and making sure that you represent the intent of this board. Obviously, I'm in favor of this bill. I think it's really important, this conversation, because there's a lot of false narrative around there about who can be helped or not without parent or guardian consent. So I'm really happy to see that they were once again spelling out the circumstances and the responsibilities, even when it comes to medical and related billing and so forth. So thank you.
Abigail?
I had a question about the parent or guardian not being liable for payment for mental health treatment. Does that mean that the minor can still bill Medi-Cal? Like, do they have, the right to say, I want to use, my health insurance, even if the parent is against it?
I believe that's the case. My understanding is that since Medi-Cal is the payer, that it would be Medi-Cal that would be taking care of the bill, not the parent unless they had consented.
Okay, and a 12-year-old can say yes to that.
If,
Mhm.
yes, if they meet the other standards that the therapist has to believe that they can participate intelligently in the process.
Okay.
All right, thank you so much. I'm also in favor of this. I think it's a great a bill that's going to create equity for our kids that need help and don't always have the support at home that is going to get them that help. Are there any questions or comments from our audience? All right, any questions from our online audience?
This is the moderator, and we've opened up the public comment feature for public comments online. If anyone would like to make a comment on the presentation, you can look for the question mark icon, click that, type the word comment and click send, or you may look for the hand icon to raise your hand, and call-in users can press *3 to raise their hand. Any comments on the minors consent bill discussion? I do not see any requests for comment. Shall I close that feature?
Yes, thank you, moderator.
Welcome.
When out of order, did we have a motion on the floor?
I would like to make a motion on, okay, now I need to read it. Hold on, let me get there.
There's no.
There is no language for that, right?
No, it would
Yeah.
just be, do you want to support it? Do you want to support if amended? Do you want to?
I would like to make a motion in support as presented.
I will second.
Any further discussion? From our audience? From our remote audience?
This is the WebEx moderator. If you have any comment on the discussion or the motion, you may click on the hand icon to raise your hand, or click on the question mark icon to type the word comment in the text box and send, and call-in users may press *3 to raise their hand. Any comments on the motion? I do not see any comments. Shall I close that feature?
Yes, thank you, moderator. Christina, will you take the roll?
Eleanor Uribe. Actually, abstain. Abigail Ortega,
Yes.
Kelly Ronasinghe,
Yes.
Chris Jones,
Yes.
Wendy Strack,
Yes.
John Sobek,
Yes.
Max Disposti,
Yes.
Susan Friedman,
Yes.
Annette Walker, Dr. Annette
Yes.
Walker, sorry.
Thank you.
Motion carries.
All right, thank you. Excuse me. Next on the agenda is item number 22, discussion and possible action regarding SB 11 from Menjivar, California State University Mental Health Counseling. Roseanne?
Yes, this particular bill would require the California State University system to have a minimum of one full-time mental health counselor per 1,500 students at each of its campuses. And then it also establishes a non-competitive grant program to provide qualifying CSU students with grants if the student agrees to complete required supervised clinical training hours to obtain licensure in California with this board or the Board of Psychology. So this bill currently, it provides a definition of a mental health counselor, defining it as somebody who provides counseling or crisis intervention or emergency services to the campus community and who is licensed in the state of California by the applicable licensing entity. It defines licensure now as a license granted by the Board of Psychology or this board. It requires certain reports every 3 years to the legislature about how funding is used, about how information about student needs and how their emotional well-being and services being provided are. And it also requires the CSU campuses to collect data on attempted suicides, all without any personal identifying information, so confidential. And the author is basically seeking to improve the counselor to student ratio on CSU campuses and also seeking to provide incentives for CSU students to provide licensure in the mental health professions to help increase the pipeline of those in the therapist licensure process to try to encourage more people to become practitioners. The board had considered a previous version of this bill in May, and it had taken a support position, and it separately had provided certain feedback to the author. The mental health counselor definition that was in the bill, it stated that it needed to be a mental health counselor licensed in California, but it didn't specify which license types were acceptable. So the board had said it may be helpful to state which license types are acceptable and also include associates and trainees. And then the board provided some feedback that while creating incentives for students to become mental health counselors was they were supportive of that. It would also be helpful that, as they pointed out, the funds could be used to help, if funds could be used to help grow the CSU mental health program capacity to accommodate additional students, that would also be helpful. Since the time the feedback was given, there has been some amendments to the bill, mainly related to the grant program and what that looks like. The authors opted not to revise the definition of a mental health counselor, but they did specify that licensure means this board or with the Board of Psychology. And so they took a little bit of the feedback, but not all of it, and they proceeded to move forward with what you see here today. Just a couple of comments on the current bill version. There is a statement in section 89362B3 that states that before receiving a grant, a student must agree to complete the supervised clinical training hours required to obtain licensure. While the student is still in school, there are some practicum requirements, but it's important to note that most of the required experience hours is actually obtained after the degree. That's fine. It just might be helpful for them to specify what the student's licensure commitment must be before receiving the grant, and the timeline for receiving that for completing that commitment. But it's not essential to this bill. I think that the effort is there, and they're trying to go in the right direction, and they'll probably be able to do that through regulations should this bill pass. I will also point out that the grant program created by the bill is contingent on funding from the legislature. And so at this time that there has not been an appropriation made. So Hopefully they'll be able to make an appropriation, but that's still to be determined. So just a caveat there. You will note that the California State University Office of the Chancellor has an opposed unless amended position. That's basically because, for a couple of different reasons, they don't like the ratio. They feel that they've made progress on the ratio of counselors to students. They are concerned that it undermines their trustee authority, and it does not include an appropriation, as I pointed out. They also say that the one per, I think it's 1,500 students, yes, is no longer supported by the National Counselor Organization that had previously recommended it. So that's the reason for their opposed unless amended. It's nothing to do with it, or at least they did not point out that it was anything to do with the grant program. So with that, I'll open it up for discussion.
All right, thank you, Roseanne. I have a question. With the ratio, as far as whether or not we as a board would support or not support that number based on what is recommended by the Counselors Association, is that an important piece for us to think about with regards to helping move this bill forward?
Overall, I would say no, that in general, the bill makes I think a step toward trying to increase the pipeline. The more of the reason that I brought this bill before the board is because of the board has similar concerns in trying to increase, how do we encourage people to enter the mental health profession? It's really less about the actual ratio and arguing over those numbers. If there's a concern, we can certainly point that out, but I think that overall, it's more about that grant program and how do we encourage people to actually enter the mental health professions and reduce some barriers to entering the mental health professions for them. So if there's an effort and we can be supportive, I think it's important to be supportive where
Perfect.
that's possible.
No, thank you. I appreciate that. Any other discussion or questions from the board? No? Okay. How about our audience?
I just want to say, as a student, I think this is really important, especially I lived on campus this last year and saw a lot of younger students struggling with depression and suicidality while I was there. And I think it's just really important that we can give as much access to mental health services at our CSUs in California. Thank you.
Thank you. Any comments from our remote audience?
This is the moderator, and we've opened up the public comment feature of WebEx. If you'd like to make a comment on the bill, you may look for the hand icon and click that to raise your hand. You may look for the question mark icon, click that, type the word comment in the text box and click send, or our call-in users may press *3 to raise their hand. Are there any comments on the Cal State University Mental Health Counseling Bill? I do not see any requests for comment. Shall I close that feature?
Yes, thank you.
Thank you.
I would like to propose a motion to support the bill as it has been amended.
And I'll
Is that the right verbiage?
Second.
I heard Wendy.
That's fine. That's it. She can,
Alright.
it's fine.
You got
I'll get the
arm
next
wrestle
one.
for it?
We had 3 seconds. No, I'm kidding.
We have second and a third. Any further discussion? Any further discussion from our audience? Our remote audience?
If anyone has any comment on the motion before the board, you may look for the question mark icon, click that, type comment, and click send. You can press the hand icon, or if you're a call-in user, you may press *3. No request for comment at this time. Shall I close that?
Yes, thank you, moderator.
You're welcome.
All right, Christina, can you take the roll?
Dr. Annette Walker,
Yes.
Susan Friedman,
Yes.
Max Disposti,
Yes.
John Sovik,
Yes.
Wendy Strack,
Yes.
Chris Jones,
Yes.
Kelly Ranasinghe,
Yes.
Abigail Ortega,
Yes.
Eleanor Uribe.
Yes.
Motion carries.
Thank you. All right, next on the agenda is item number 23, discussion and possible action regarding SB 238, Weiner Healthcare Coverage Independent Medical Review. Roseanne?
Thanks. So under current law, consumers have a right to request an independent medical review of their health insurance plans, finding that a service is not medically necessary. If the health insurance rejects based on medical necessity, the consumer must first file a grievance with their plan and then undergo a 30-day review process, at which point then they can decide to request an independent medical review regarding the outcome. So this particular bill seeks to reduce barriers to mental health care for children and young adults by making the independent medical review process automatic rather than consumer-oriented for mental health treatment and substance use disorder treatment for children and young adults up to age 26. And the bill is, I would say it's substantially the same as what the board considered in May, but some amendments have been made to the actual process along the way that are more substantive that we can't just continue to support it without the board reviewing the bill again, because the wording has pretty significantly changed, but the idea is still pretty much the same. It's just how they get there, and some of the processes were changed a little. So the bill establishes that within the state that under the independent medical review system, a health care plan enrollee can request review of grievances involved in a disputed care services if specific requirements are met. The health care service plan and insurers must prominently display the information on the right of an enrollee to file a grievance. The independent medical review organizations that the state contracts with must be independent of any health care service plan or disability insurer. And then the state must adopt the determination of the independent medical review and promptly issue a written decision that is binding. So this particular bill, as of July 1, 2024, would require that the decision be submitted within 24 hours to the state's independent medical review system without requiring the enrollee to submit a grievance. And the author notes that the reasoning for that is a lot of times there are language barriers or other barriers where somebody didn't even know that they could file a grievance. So this just makes it easier for that process to automatically happen. Within that 24 hours after submitting, the disability or insurer or healthcare plan must notify the enrollee and provide them copies of certain documents and notice that they can cancel the independent medical review if they don't want it. If for some reason they decide they don't want to, they have that right. So they have to notify them. And they also to note, the healthcare plan will be required to let the person know that they can provide additional information or documentation if they would like to. At the May meeting, the board had considered this bill, the previous version of it, and had taken a support position. And so with the amendments today, we are asking if the board wants to reconsider its position.
Comments from the board? Kelly?
I have fairly strong feelings about this. I think it's a very important bill that removes barriers to people contesting negative decisions by their health plan. The health plan administrative process to appeal negative decisions of denials of service is extremely complicated. It's complicated for lawyers, let alone people with language barriers or who are underprivileged or in rural areas. It can be easy for health plans to jam up these appeals prior to conducting an independent medical review, requiring a person with an existing medical condition to basically seek outside costs, through private costs, rather than go through the independent medical review process. So I'm in support of this bill.
Is that a motion?
Is that a motion?
Yeah, sure. I would.
That would second that.
I would move to support this bill.
Thank you, former chair. Dispersey.
Sorry.
Are there any comments from the audience? Any comments from our online audience?
This is the moderator. If anyone has any comments on the proposed bill or the motion, you may look for the hand icon to click on that to raise your hand. You may click on the question mark icon, type the word comment in the text box there and click send. And any call-in users may press *3 to raise their hand. Are there any questions or comments on the independent medical review bill? I do not see any requests for comment. Shall I close that feature?
Yes, thank you, moderator.
You're welcome.
Christina, would you please take the vote?
Eleanor Uribe,
Yes.
Abigail Ortega,
Yes.
Kelly Ronasinghe,
Yes.
Chris Jones,
Yes.
Wendy Strack,
Yes.
John Sovek,
Yes.
Max Disposti.
Yes.
Susan Friedman,
Yes.
Dr. Annette Walker.
Yes.
Motion carries.
Thank you. Next is item number 24 on the agenda, discussion and possible action regarding SB 372, Department of Consumer Affairs, License and Registrant Records, Name and Gender Changes. Roseanne?
Yes, so SB 372, this is the bill that the department and the author's office, including all the boards, including this board, has been doing a lot of technical support to sort of move this bill along and get it in a form where it can be implemented and that everybody is sort of happy with the way that it's working. It's a bill that would require a licensing board under DCA to update a license or registration, including any references contained in its online license verification system, to include a licensee or registrant's updated legal name or gender, and remove the former name and gender from being published online. When that licensee or registrant provides specific government-issued documentation that their legal name or gender has been changed either to match their gender identity or due to a need for confidentiality because of certain domestic abuse situations. So currently, certain boards under the DCA, due to BPC Section 27, are required to post certain public information on the internet regarding the status of every licensee, including the licensee's status, disciplinary actions, and address of record in accordance with the California Public Records Act. A licensee or registrant must provide the board with written notice of a name change, giving both old and new names within 30 days of the issuance of a new government issued photo ID. Currently, also the law in the Code of Civil Procedure and the Health and Safety Code sets forth a legal process for the court to follow when a person is petitioning to change their name or birth certificate, gender, and sex identifier to conform to their gender identity. And also the law in the California's Code of Civil Procedure sets forth a legal process for the court to follow when a person is actively participating in an address confidentiality program and is petitioning to change their name to avoid domestic violence, stalking, sexual assault, or human trafficking. So there's certain procedures for those particular types of changes. This bill would require the DCA board to update the individual's license or registration with on their request by replacing references to their former name or gender with references to their current name or gender if they provide the required documentation. Boards that operate an online license verification system must, upon request, if somebody's name or gender was updated under one of those two programs, either name change due to gender identity or address, or to avoid certain types of domestic violence, they must replace references to the former name or gender with the current name or gender on the publicly viewable information about that online, and the former name or gender shall not be published online. The bill also provides that if one of these license or registrants were previously subject to an enforcement action that references their former name or gender, that the disciplinary records not be posted online, but instead the board must post a statement that the individual was previously subject to enforcement action, and it would direct the public to contact the board for more information about the licensee or registrant's prior enforcement action. And then if they were the board were contacted, the board must ensure compliance with the California Records Act meaning that they would need to respond to the request for records within 10 days from the receipt of the request. The bill also requires that if the public searches a board's online license verification system using a former name that had been replaced due to a name change for one of these circumstances, that the board must post an online statement directing the searcher to contact the board for more information about the licensee or registrant. The bill would require a board to reissue the license created by the board if requested, and it must not charge a higher fee for reissuing that document with the updated name than a fee it would regularly charge for reissuing a document for any other reason. And then it provides that all records related to a request by the licensee or registrant to change their name for the reason specified in the bill are confidential and not subject to public inspection or disclosure. And so this bill, the board was in support of this bill at its May meeting, with the understanding that the bill was very highly likely going to change. There was a lot of kind of everybody generally agreeing that it was a good first step, but there were a lot of logistics and how this would work out. So the author's office and the department, I think, did a lot of work to get this bill to where it is today. And it, I think, resolved a lot of those concerns. So let's see, a couple of different things that I want to bring up. Right now, I should remind everybody that if somebody changes their name, the board displays the old name and the new name. And so this bill would address that for certain situations. In terms of the current board process for a name change, right now, there's no fee to actually legally change a name. The fee comes in when they need to request a replacement license or registration certificate. That's what they display for their clients to see. That has a $20 fee for it. The fee is standard for all replacement certificate requests. It doesn't have, the fee doesn't change based on the reason for request. So that part of the bill, I think, is not a concern that it says you can't charge a higher fee. The board already doesn't do that. The bill discusses gender changes. This particular board, I don't know about others, this board does not collect information about gender on licensees or registrants, and therefore that's already not displayed on the Breeze online license lookup. So, like I said, the board previously had a support position on this bill. I think this bill, it kind of addresses one concern, but the previous version of the bill would have required all name changes to be confidential, regardless of what the reasoning for. This really targets two particular concerning instances in terms of a name change due to matching gender identity, or a name change due to certain domestic abuse situations, which is more in line with the author's intent of the bill to protect these specific groups who might be more likely to suffer negative consequences of their previous name being made public. And so that is pretty much, you'll see the support and opposition, that's not, since the bill was recently amended, that's not up to date. I think a lot of boards are still in the process of reconsidering. So if you see a particular board opposing or opposing less amended, they're probably in the process of reconsidering that, just like we are too. So yeah, that'll open it up for discussion.
Thank you, Roseanne. Discussion?
Yeah, Max Disposti. Thank you, Chair. Once again, thank you so much, Roseanne, because this is, we have seen an evolution of this bill, and it's been very important. Just a few months back, I don't know if it was even a year or so, but the initial conversation was about the balance between consumer protection, right, a transparency about requests of records, and privacy and confidentiality of our licensees. And I like to see that finally there is an understanding that the idea of privacy and confidentiality wasn't just like an option of a choice. It's kind of like, I really would like my name. No, it has to do with safety and up to violence and death in some cases. So I'm really happy to see how this conversation has evolved to understand that obviously we're a consumer protection agency, but not to the expenses of the life of our licensees. So creating that balance that's very delicate. I just want to commend the work behind this and the fact that the conversation has evolved in creating that right balance. And I know there is still a lot of work to do, but I just want to commend you once again, Roseanne, for following up with this and bringing our perspective forward as well. Thank you.
Any other comments? Board? Eleanor?
So maybe I might need to read it again, but as far as like victims that are in domestic violence, isn't there something that can be used currently that can protect them?
There's a mailing address, Safe at Home program, but it doesn't do anything for your name with us.
Uh-huh.
They provide a mailing address
Uh-huh.
that's confidential.
Okay. Yeah, I think for me, I would have liked it to be separated, but just because I think that should happen, if there's someone regardless, that they should have protection. So, yeah, thanks.
Anything else? Do you have a motion on the floor?
I'd like to make a motion in support of the bill.
Do I have a second?
Yeah, I'll second. Yeah.
All right. Do we have any comments from the audience?
Real briefly, Rebecca Gonzalez with NASW California. I just want to point out that all the professional associations that usually attend these meetings, NASW, CAMPT, and licensed professional clinical counselors are all in support and co-sponsors actually of this bill. Thank you.
Thank you, Rebecca. Any comments from our online audience?
This is the WebEx moderator. If anyone would like to make a comment on the bill or the motion under discussion for the licensee and registrant records, you may look for the hand icon, click that to raise your hand. You may look for the question mark icon, hit that, type the word comment and click send. Call-in users may press *3 to raise their hand. We do have a request for comment from Kathy Atkins. Kathy, I'll send you a request to unmute your microphone. You'll have 2 minutes with a 15-second warning. You're unmuted.
Hi, this is Kathy Atkins with CAMP. Thank you to Rebecca for acknowledging the coalition's efforts. And I wanted to specifically highlight, underscore, and thank all of Roseanne's work on this bill. I believe someone mentioned the technical aspect and the amount of time Roseanne has worked with our coalition to help this move forward in a way that is acceptable to all stakeholders, as well as the incredible amount of weeds that she's had to get through to help us, frankly, just cannot be stated enough. So I just really wanted to acknowledge it publicly of how much work she's put into this and just thank her.
Thanks, Kathy.
Thank you, Kathy.
And I do not see any other requests for comment at this time. Shall I close the public comment feature?
Yes, thank you.
Welcome.
Any other comments from the board? All right, Christine, would you take the vote, please?
Dr. Annette Walker,
Yes.
Susan Friedman,
Yes.
Max Disposti.
Yes.
John Sovek.
Yes.
Wendy Strack,
Yes.
Chris Jones,
Yes.
Kelly Ronasinghe,
Yes.
Abigail Ortega.
Yes.
Eleanor Uribe.
Abstain.
Motion carries.
Thank you. All right. As previously stated, we took items 25 and 26 off the agenda for today. We're going to move on to agenda item number 27, which is discussion and possible action regarding SB 544, the Bagley-Keene Open Meeting Act and teleconferencing. Roseanne?
Thanks, Chris. So SB 544 was just amended a few days ago. And this is the bill, I think you heard Melissa Gear earlier in today's meeting in her DCA update reference. This is one that a big one that we've been watching regarding board meetings and the requirements for conducting a meeting via teleconferencing. So as you know, existing law establishes the Bagley-Keene Open Meeting Act, and and sets all of the requirements for boards to conduct a meeting both in person, and then it'll provide certain requirements if a meeting is going to be conducted via teleconferencing. So currently, all meetings of a state body, of course, need to be open and public and all persons permitted to attend. The law currently does not prohibit a state body from holding a meeting by teleconference, but a teleconference meeting has to meet certain requirements. It needs to be audible to the public at the locations specified in the meeting notice. It requires the board must post agendas at all teleconference locations, and it must identify each teleconference location in the notice and agenda of the meeting and make each teleconference location accessible to the public. It also must provide an opportunity for the members of the public to address the state body directly at each teleconference location. And one member of the state body must be physically present at the location specified, the main location specified in the notice of the meeting. So this was established, of course, before the COVID-19 state of emergency. The governor temporarily waived some of the teleconferencing requirements so that boards could continue to conduct state business during the COVID state of emergency. But once this COVID state of emergency ended, some of those temporary requirement waivers have now ended. And so boards are back to being required to meet in person, or if board members want to meet for, say, from their house because they can't make it for some reason, then the location where they're from has to be posted on the agenda, which can be problematic if it's a home address, and it has to be accessible to the public. And so there have been negotiations going on at the legislature to try to figure out, because teleconferencing increased access for a lot of people, how do we balance the public's right to know and participate in these meetings with having teleconferences, and how do we make that fair and equitable for everyone without having these safety concerns? So this bill, as it's written today, would remove the requirement that a state body conduct a meeting by teleconference, has to post agendas at all locations, identify each location in the meeting notice, and make each location accessible to the public. Instead, the state body would need to provide a means for the public to remotely attend and observe at least one site on the posted agenda, and this must include access equivalent to access a state member participating would have if available. The telephone number, website, and physical address to attend must also be specified in the meeting notice. The meeting agenda must provide an opportunity for members of the public to address the state body directly. And instead of requiring one member of the state body to be physically present at the location, it would require at least one member or staff to be physically at the location. And then the new requirement that was just added to this bill earlier this week is that it would require a majority of state body members be present at the same physical location for at least half of the meetings for each year. So that's the major change to this bill since the last time you heard it. The other major change is that it had added a sunset date of January 1, 2026 to kind of, I think, see how it's working at that time. When the legislature looks at it 2 years down the road, they can either decide to make changes or extend it. And so that's pretty much the main changes that you're seeing today. The board had previously taken a support position on this bill. But like I said, the requirement that a majority of members be physically present at half of the meetings per year and the sunset date were most recently this week added in. So I don't see any major concerns with the new amendments. Board staff would need to track under this system whether each board member attended in person or remotely for each meeting to ensure compliance with the physical present requirement over the course of the year. But that's not something that's doable. And so we are back here today to see if the board wants to update or change its position in any way.
Any comments? John?
I have a quick concern about, especially with our smaller committee meetings, sometimes it's 3 people. So that half like having a majority forward, half of the meetings a year really doesn't make much change for what we're doing. Is that correct?
That is true. With committee meetings, it would be a little bit more, it's going to, the bar is a little bit higher because those meetings are so small and there's so many of them. Most of those would pretty much have to be in person, the way that I read it. You know, somebody, if they had if a board member had a hardship, however, let's say that somebody was ill and couldn't attend, but still wanted to attend remotely, that would make that possible without having that person's address be published, is the main takeaway from that.
And you could still do like we normally do with the published addresses, correct?
We wouldn't need to publish the address anymore.
I mean, if you did a full teleconference.
There would just need to be, if it was a full teleconference, there would need to be like, if it was the hearing room was the main site,
Right.
then that's the address that would be published. But if John decided, well, I can't make it to this meeting for whatever reason, he could teleconference in and it
Right.
wouldn't require, oh, you have to post your home address all of a sudden.
But then we would still have to have two, so the committees meet quarterly, basically, right? So
Right.
4 times a year. So in 2 of those meetings are, and I'll use the telehealth committee, because there's 3 of us that are on there. So for 2 of those meetings, Kelly, Susan, and myself would need to be here or somewhere. We could be at Starbucks and out in El Centro. That's the,
Pretty much. I mean, it's a little bit there. I think that the way that it's written, you know, if Chris said, I never want to attend the telehealth meeting in person again, but Kelly and Susan decided that they wanted to, that might work with the numbers. We would have to kind of crunch it out.
to take turns on
Yeah.
who's got to go.
It does allow somebody who, you know, has some sort of a hardship or emergency to still opt to attend if they would like. It's just not something that can be done pretty much basically every time.
Right.
And that's the opposition. A lot of it was like broadcasters groups that were opposed, and just the concern about transparency and having the concerns that they were voicing in their opposition was basically like, we don't want these state bodies to never have to even interact with the public again. They just, you know, are not ever coming to a meeting where we can talk to them.
Right. I think one of my concerns, and I think my fellow board members agree, you know, these committee meetings can be fairly short. And, you know, for me to fly up from Los Angeles for a 2-hour meeting is an 8-hour day.
I know.
And you know, just the lack of efficiency and lost time is not great. It may impact the willingness of board members to you know, be on committees.
And maybe, you know, Roseanne, do they differentiate? It says the majority, half of its meetings each year, the state body. Now, would that mean half of all of their meetings, or do they differ? I don't know. I didn't see where they differentiated between committee meetings versus just all of the meetings.
It defines
Yeah.
the state body as, let's see.
So what I'm saying is that it's
they're
all, you have them in the one bucket, all of your meetings, right? Half, you're right. So you're not, so you could do your small committee meetings teleconference if that's how I'm reading it.
You could.
Okay, well, if you do that, okay, but if you do that math, right, how many committees do we have? 3?
3 right
3
now.
committees, and we have the board, so that's 4, so that's 16. So that
Mhm.
means 8 meetings across all of the different boards and committees would still have to have half of the people.
You can figure out that P&A
Right.
is bigger, you know, I mean.
Okay,
Yeah.
so 4 for sure, because we're all here in person for the board meetings, right? So the 4 other committees, if I'm doing the math, it probably would be feasible as written?
It offers us more flexibility than we were currently going to have if we don't pass this.
I think
through.
it's
So,
not,
I mean, that's kinda-
it's definitely not perfect and it raises some questions,
Yeah.
but I think it offers a better option than we have right now, where it still kind of requires a lot of in-person meetings probably but at the same time, it allows somebody, if they really can't make it.
Right.
And-
you just have to get a little bit creative with your numbers. If you just add them up and then you have your smaller committees can be remote to save the time and money, and then the larger committees, and I think it's like staff is going to have to be creative.
Yeah, it's gonna,
And the sunset date allows us the opportunity to reflect upon whether or not it's effective.
Right, yes. It's a 2-year, which I think is, this bill we've seen this bill a couple times in the past year and it hasn't even gotten committee dates in the legislature because it's been so controversial that it's just been killed. So I think that this is progress. I agree that it's not perfect, but it at least is moving towards something that's better than what we currently have.
Okay.
Mr.
Susan, go
Chair,
ahead.
one
Oh,
comment of,
Wendy?
instead of disincentivizing board members to participate in committees, perhaps for the good of the whole, this would incentivize board members to participate in committees, because if we had larger committees, that reduced the burden on the individual people who have to come in person all the time. So if we
Look
had
at-
broader participation in our committees, that would provide more flexibility as well.
Vice Chair Wendy, cup half full Strack. I like it. All right. Susan?
First of all, I couldn't hear what Wendy said. She said it in that. Anyway, I wanted to ask you, the purpose of do you know anything about the author of this bill? Sorry. Do you know anything about the author of this bill? And is the purpose to make sure that things don't happen without the public knowing? So when it's a subject that could be really controversial, like we're not going to have any more tests for people to become licensed therapists anymore. That would be so controversial. That should be a meeting in which the public should be present. That committee meeting. I mean, do we have a choice of how to?
The bill doesn't go into what topics are discussed. So all of the meetings, whether they're teleconference, there has to be the 10-day notice, and there has to be a platform, just like we did during COVID. I mean, we discussed some controversial topics then, and there was still public participation. It's just allowing the kind of a mixture, a hybrid of what we were doing. I think that, if you're going to have this a course of meetings over a year, some of them have to be in person.
Well,
yeah,
let me ask you
and I think
one
I'm sorry.
other thing. Does it say that if you're going to have a meeting, it can't be an open meeting like a Zoom or something where the public could participate?
Well, all our meetings have to be open meetings. And I think the author's really intent is like what you're saying, is participation of the public, because that's the whole intent of the Bagley-Keene Open Meeting Act, is to have that participation. So I think the concern of the concerns that are raised is just to make sure that there is that open meeting and that there's full participation and the public has the ability to participate.
No,
Yeah. So
But we
that's,
don't have to have it in Sacramento.
no, I
So
would,
for example, because Chris and Kelly live in San Diego, you could say someplace in San Diego or.
yeah, I mean, we could have the meetings everywhere. I mean, the whole intent of the law is for the open meeting. And so what this is really addressing is currently right now, where a board member, if we are having a meeting in different locations, you're going to have to put, you have to put a location that's accessible and that the public can participate in the meeting from. So currently right now, if we had this, you would have to, if you wanted to put your home, you could. Sure, you wouldn't want to. So it makes it a little bit easier. It gives us the flexibility to be able to actually continue somewhat how we were doing during COVID. We're utilizing teleconferencing a little bit easier and utilizing the virtual meetings a little bit easier.
And I have to say, using the new platforms like WebEx, and I know we're not using Zoom anymore. We had a really bad experience with that. Using WebEx, we have had the most public participation we have had in years across all of our boards and bureaus. We had over like 400 participants at one point at another one of my boards in one meeting. And so with that, that's part of this bill, is getting those platforms out there so that the public can be participating from their car, from their phone, from their bedroom, from, anywhere, from work, school. So it's really for the public also. And
And
Good
this,
change.
and it's, yeah, and it's, right now, it's currently I think it is a good change. And I think, like we said, it's kind of the best we can go for right now. And we'll see after 2 years what we can kind of see how that works out. And I mean, like you said, I think for us, our participation's never, I mean, that grand, but during COVID, yes. I mean, we saw numbers that were way beyond what we usually get. So it's excellent.
I would add from the feedback that I've heard, I think there are a lot of boards that would like this bill to go even further in terms of, possibly doing all online. But I think that it's the state is trying to strike a balance with its public meetings. As you can see with the opposition, you'll see a lot of state boards in favor and a lot of news organizations against. And it's just that, how do we balance, the ability to have these teleconference meetings with public transparency? And the state is trying to sort of strike that balance in a way that everybody can agree on.
Kelly?
I would move to support the bill.
I will second. Discussion from the audience?
John DeLine, MFT student, I would say that any ease of accessibility to board meetings would be beneficial, I think, for everyone, including people who would like to be more involved, like myself.
Thank you. Any comments from our online audience?
This is the moderator, and we've opened up the WebEx public comment feature. If you'd like to make a comment on the motion or the bill, you may click on the hand icon to raise your hand, or you may click on the question mark icon, type the word comment into that text box and click send. And our call-in users may press *3 to raise their hand. Are there any comments on the bill or the motion? I do not see any requests for comment. Shall I close that feature?
Yes, thank you, moderator.
You're welcome.
Christina, would you please take the vote?
Dr. Annette Walker,
Yes.
Susan Friedman,
No.
Max Disposti,
Yes.
Jan Sovic,
Yes.
Wendy Strack,
Yes.
Chris Jones,
Yes.
Kelly Ronasinghe,
Yes.
Abigail Ortega,
Yes.
Eleanor Uribe.
Yes.
Motion carries.
Thank you. Next on our agenda is the discussion and possible action regarding clarifying the term supervisee. Roseanne?
Thanks, Chris. So this is a discussion that we had at our past policy and advocacy committee meeting in July, and the committee decided it would like a little bit more feedback from the board on how to go forward with this. So I'm going to present this in two parts because there's actually two separate code sections that are under consideration here. So I'll present the first one and then I'll stop and we can discuss, and then I'll present the second one. I think it'll be a little bit less confusing to do it that way. So currently the board's practice acts reference the term supervisee, but there's not an actual definition in the practice acts of a supervisee. It's probably a definition that's not needed because in the context in which it is used in the board's practice act, it can be reasonably inferred to mean an individual required by the board to be under supervision. An individual might be required to be by the board to be under supervision for a number of reasons. The most obvious is they're an associate and gaining hours toward licensure, but also there's other people that are required by the board to be under supervision. If you're working in a non-exempt setting, then registration and supervision are required in order to provide clinical services, even if you're not gaining hours. If you're working under the 90-day rule, supervision is required even though you're not registered yet. And then if you're an MFT trainee, you're counting hours toward licensure. So even though you're not registered, you are still required to be under supervision. So it can refer to a lot of different people that are in various places in the licensing process. There's two particular instances where the above might not apply and the intended definition becomes unclear. So the first one I want to talk about is the definition of direct supervisor contact. And that is in each of three of the board's practice acts. It's in LMFT, LCSW, and LPCC. And these particular subdivisions define individual supervision, triadic supervision, and group supervision for purposes of direct supervisor contact. The current definition includes one supervisor and a specified number of supervisees. For example, for group supervision, it's defined as one supervisor and 8 supervisees. So the term supervisees in the context of the Board's Practice Act refers to individuals required by the Board's Practice Acts to be under supervision. However, when you're limiting the supervisees per supervisor to a particular number, we've had some questions that have arisen that the law does not quite address. So if you look at the group supervision definition as one supervisor and no more than 8 supervisees, we had the question asked, well, what happens if my company is requiring a licensee to be in that supervision group? Maybe because they feel that that licensee needs some additional supervision attention. Does that count as one of the 8? Well, the law doesn't address that. So there also might be a case where there was a pre-licensed psychologist who's not regulated by this board, might be participating in the supervision. And those individuals also do not fit the implied definition of a supervisee because they're not required technically by the board to be under supervision. But they are still taking a spot in the supervision group, which was likely limited to 8 in order to ensure that each group supervisee gets the proper attention from the supervisor that they need to learn. So attachment A shows a possible solution to this issue. Instead of limiting the number of supervisees to 8 for group or 2 for triadic, it limits the number of, quote, persons receiving supervision for providing clinical mental health services. So that would capture not only the board's associate trainee and trainees and 90-day rule applicants who are required by the board to be under supervision, but it would also capture individuals such as, for example, psychology pre-licensees or psychologists, or a licensee of this board who is being required for some reason by their employer to undergo extra supervision as part of their job. And so as you can see, that language is in attachment A. And I'm going to stop here in order to keep the discussion simple. I think I'm going to stop here and we can discuss that piece and then move on.
Discussion?
So I have a question.
Kelly?
Roseanne, so the broader definition of supervision only refers to supervision toward licensure, not supervision, just supervision. So it could not be interpreted as this guy's supervising a junior therapist who's already licensed.
So yeah, in the context of how supervision is used in our practice acts, it's somebody who is required by the board to be under supervision for purposes, it's usually for purposes of gaining hours toward licensure is what the Practice Act assumes that they're doing. So they have to be under supervision because they're gaining hours, or if they're not gaining hours, they're working in a setting where the board requires a supervision, as it's very specifically defined, to be taking place for that person.
Got it. And option A would capture non-board supervisees.
Yes.
So
And
you couldn't double up. You couldn't
Right.
like do 8 and 8.
yeah,
Okay.
right now it really technically doesn't. And we got that question and Camp got that question. And so when we looked at it, and the questions come up a few times now, and it's like, well, it really doesn't, there was an agency that was requiring, I think it was an LMFT, to undergo supervision with this group of supervisees. It's like, well, does that LMFT count? And technically the law just doesn't account for that.
Gotcha. Thank you.
Anyone else? Okay, Roseanne, continue, please. Thanks.
Okay. So that's the issue is attachment A is under consideration today. Then I want to move on to attachment B, which is a separate but related issue and question. So there are 3 sections, one for LMFT, LCSW, and LPCC code that require supervisors of supervisees in non-exempt settings to have no more than 6 individual or triadic supervisees at any one time. So, and I should say that the reason it says non-exempt settings is because in exempt settings, which is a school, college, nonprofit, or government agency, there's no limit on the number of supervisees per supervisor. But in non-exempt settings, there is a limit. It's 6. So The section goes on to state that supervisees can be associates. Basically, it says you can have 6 supervisees and they can be any combination of the 3 types of associates that the board has. The reason for limiting the number of supervisees is to ensure that a supervisor can dedicate enough time to properly supervising each one. Because there's a lot of things that have to be done. You have to have the supervisory plans and the weekly check-ins and things like that. So the board wants to make sure that somebody doesn't have so many supervisees that they can't do a good job supervising them, basically. However, the law stating that it only includes associate leaves out other potential types of supervisees, such as trainees, those under the 90-day rule, or those seeking a license with the Board of Psychology. So it's possible that the intent of the law all along was to limit the types of supervisees to 6 in non-exempt settings to ensure quality supervision. So we've, and this is kind of a nuanced discussion, but attachment B shows some proposed clarifying language for the subdivision. So as shown, the language clarifies that the supervisors of supervisees in non-exempt settings are limited to a total of 6 supervisees. That's the first thing it does. And the reason we're doing that is because currently there's confusion about whether the 6 supervisees per supervisor is 6 per setting or 6 total across all settings. And it's supposed to be 6 total across all settings, but we've tried to clarify the language because we get a lot of questions about that. So that's the first thing. The second thing the language does is clarify that supervisees include not only registered associates, but also anyone who's gaining supervised experience toward licensure with the board in a non-exempt setting. So that option would include MFT trainees and 90-day rule applicants, but it would not include the way that that particular option is worded. It would not include PCC trainees or social work interns because those individuals don't gain pre-degree hours. So those wouldn't count toward the 6. So that's kind of confusing there. And it would also not include other mental health professionals such as psych board registrants. So that's where kind of the subtle difference is. The second part of attachment B, subdivision C2, and there's some language in italics that I think might work better. If the board wished to include all possible supervisee types in the 6 supervisee limit, the language could say individuals who are receiving supervision for providing clinical mental health services in a non-exempt setting. That would basically include everybody. It would include not only associates and MFT trainees and 90-day rule applicants, but that would also bring in the PCC trainees and social work interns and those being supervised for other types of mental health services not licensed by this board. So there is a couple of options there for attachment B if the board wants to go through with that. And then finally, another thing that I brought up that I think that the P&A committee kind of gave feedback that they weren't too concerned with, but there's another common issue that staff gets questions on occasionally that could potentially be addressed here is supervisors and supervisees are sometimes confused because the law limits a supervisor in non-exempt settings to 6 individual supervisees, but the law also in group supervision for group supervision allows up to 8. So people get confused between the 6 and the 8. So the board may wish to discuss if any changes would be helpful here. The Policy and Advocacy Committee had discussed this at its July meeting, as I said, but felt that discussion with a larger group of people might be helpful, so opted to bring the language to the board for further discussion. So I will open it up for discussion.
Discussion? Okay. No discussion. Do we have a motion? Okay.
I wanted to say one thing. I remember like during the P&A committee meeting that like there was talk about gathering more information from agencies and people that are in these situations before we can like determine like really what is the need. I remember that vaguely.
We talked a little bit about gathering some information about, there was a piece in there that we had taken out about Also specifying who could be observing the group. And the discussion, as I recall, is kind of, well, if we're going to do that, we probably want to get some feedback on who's usually included in these groups. I don't know that in terms of just clarifying this, that there's a lot more information we could really gather that would help the board in its decision. I think that just some clarity of what the board sort of wants for public protection, what it intends, is here. We took the piece out about the observing because the P&A committee with that piece felt that trying to specify who is sitting in or not just as observers could get really complicated really fast and could lead to some unintended consequences.
Okay, we're quiet today. Excellent. So, John.
Fine, Max, I will speak. So for me, I think this bill, I'm moving forward with this type of policy is really important because that supervision space is really, really sacred and really important. And we're talking about like looking at long-term changes and how we bring people through their licensure process with testing and stuff like that. So I think this in some ways is actually beefing up that long-term goal of ours by saying we want to get really specific and really tight with what's happening in supervision, that we want people who are moving through their program to get educated to, if we went with this idea of, that it's a multi-pronged approach toward licensure, that space becomes much more concise and much more clear as to what we're asking in there, who's in that room, and what the education is happening in there. So for me, I think it's really important to tighten up this language and to create spaces where you have the trainees, the interns, the 90-day rule people all there to continue their education to become the best therapist possible. And when we create spaces where that language isn't tightened up, there can be lots of ancillary people in the room. And for group supervision, it's 2 hours. And if you have 6 people in the room who have like a caseload of 20 to 30 people, and that's only 20 minutes per person, we need to be really aware of those dynamics that are playing out in these supervision groups. And so I think it's really important to get really tight in there as this is a part of continuing education. And by having the people in there that we're moving towards licensure, getting the most attention they can from their supervisor, that's what this language and this policy change really helps with.
It sounds like a motion, John.
Is there a motion here or it's just continue on with the process? Because I don't see a motion.
So for attachment A, I think that it's either do you like a language or no. For attachment B, it's the question really becomes if you want to make a change at all with C2, do you want to limit it just to those gaining supervised experience, or do you want to have it include in the 6? Do you want the 6 supervisees to include anybody who's providing clinical mental health experience, or do you instead want to only have the 6 include people who are just gaining hours? And there is a big difference there. So that's really the main question I think on the table for today. Then we need to go back and draft this for the other 2. Once the board decides what it wants, I need to draft the language for the other 2 license types. Right now, it's only drafted for LMFT. So I would recommend bringing it back in the November board meeting in whatever direction the board wants to go today with the full language for all license types, and then the board can decide, have one more say of, hey, yes, we do want this to become a bill next year.
So if I'm hearing you right, then Roseanne, you need to give you direction on which amendment to, which attachment to move forward with language.
What I'm looking for, I think today would be for attachment B, part C2, which of those 2 options there do you prefer? And then have me draft the whole thing for all 3 license types that are affected by this and look at it again and have another discussion in November. And then there would be a motion.
Okay, so then it's just to give you direction. All right. Kelly?
It seems logical to capture the broader group of people who could be under supervision. Otherwise, someone who's an LMFT PhD or an MSW PhD could double up with Board of Psychology. And then they could supervise more people, but not technically be in violation. So I would be in agreement with broadening the language to individuals who are receiving supervision versus not. So.
Okay. Do we have enough, Susan?
I just have one quick question. If you save this till November, the legislature ends in July. So we're saying goodbye to this bill.
No, so this would need to be, if we wanted to pursue this change, the new legislation for the year would start in January is when we would need to find an author. So we would need to have approval to run this at the November board meeting in order to run it as a bill starting next year. It's too late for a bill to be running this year. The session's wrapping up.
Okay. Do you have all that you need from us?
What I'm hearing is that, well, other than hearing from the public,
Right.
Proceed with attachment A, drafting it for the 3 license types.
Hmm.
And then with B, I'm hearing that for C2, we want potentially individuals who are receiving supervision for providing clinical mental health services in a non-exempt setting. So the second option that's in italics there for C2.
Okay.
That's logical.
Does that meet your excellent? All right, perfect. Do we have any comments from the public?
Hello, John Deline, MFT student. I just wanted to jump off of what John said about this being a foundation, potentially even from the presentation earlier today, supervision as a means for licensure instead of a testing. If we can create the infrastructure for it where it becomes a place that it's easy to regulate and test for the certain skills, this could be a pathway of getting rid of licensing exams in general and their problematic racist past. Thank you.
Thank you.
Ben Caldwell, LMFT. I just wanted to thank Roseanne for her work on this. There were some issues that came up at the committee level that I really appreciate your taking the time to address. This is another one of those things where the precise language can move some edge cases kind of in one direction or the other. So really appreciate your thoughtful work on this. Thank you.
Thanks, Ben.
Rebecca Gonzalez, National Association of Social Workers, California chapter. Thank you for this discussion, and thank you, Roseanne, for all your work on this. And I apologize, but I just want to make sure that I completely understand. So for both of everything we're talking about, do social work interns play into any of these discussions or not?
Yes.
And is it in both or just the second?
It would be in both, because for attachment A, for example, for group supervision, it would mean somebody that's receiving supervising. So the 8 would count anybody who is receiving supervision for providing clinical mental health services would count it as one of the 8. Where currently it's not clear. It's just a supervisee.
Right.
So that would bring more clearly everybody into that.
Okay. And the same for the other.
The other one,
The second, I guess the B.
well, for social work interns, we're talking just about non-exempt settings. So it would be to a lesser degree. Social work interns can't work in a private practice or a professional corporation, but they can work in certain types of non-exempt settings. So in some scenarios, if they would count against the total 6 if they were receiving supervision for providing clinical mental health services in a non-exempt setting. They would be one of the 8 because they would be one of the people that the supervisor was needing to supervise.
Right. So I think when I had been here before, it's a hard question for us, because we are concerned that people who are working towards getting their hours towards licensure, such as ASWs, we want them to be able to find a supervisor, and that's very challenging right now. And so maybe, social work interns shouldn't be taking those spots in the group. And also the supervision you give for an MSW is a little bit different than the supervision you would give for an ASW. So we still have, concerns if it's the best thing to include them in this or not. And I think we were concerned that maybe we should not include them. Does that make sense to you? I don't know.
That makes sense. I would point out though that because MFT trainees
Right,
count pre-degree hours,
right.
they would be included. So then we run into that situation where it's like, why are we including MFT trainees and not social work interns if they're providing clinical services?
Okay.
So yeah, it's a really nuanced, complicated discussion when you kind of get into all of the things that all of the different, people in different places along the licensure process for the different license and how the law sort of treats them different. And then how, whether that should be here or if there should be carve outs for anyone or not.
Or just give us hours for pre.
That's a whole other discussion.
I think that, we're okay on, going along with the recommendations that you're making, but I would really want us to evaluate these changes if this law passes and make sure that it's not exacerbating any problems people are finding, or finding supervisors, if it's making that problem worse. Thank you.
Okay.
Is there a way for you to stay in touch with Rebecca as you're looking at the language that you're drafting, so that so when we come back in November, she doesn't go, oh.
Well, the language, so if the board, the language, I think she sees the language, it won't change from November from what we're talking about today. It's just her concern is that, right now it's social work interns don't necessarily count against that total of 6. The question of should they, and is that going to exacerbate their hardship finding a supervisor? So I think it's a fair question. It's not going to change between now and November.
Okay. All right. Okay, thank you. Any questions from our online audience?
This is the moderator. If there are any comments or questions about the bill or the motion, you may look for the question mark icon, click that, type the word comment and click send. You may look for the hand icon, click that to raise your hand, and call-in users may press *3 to raise their hand. We do have a request for comment from Kathy Atkins. Kathy, I'll send you a request to unmute yourself and you will have 2 minutes with a 15-second warning. You're unmuted.
Kathy Atkins with CAMFT. I just wanted to comment appreciation for the BBS to continue to work with the stakeholders on this issue. CAMFT does receive quite a few questions on the topics we're discussing right now, and CAMFT does not have a strong advocacy position on how it should be written or that specifically as much as just clarity. And so we appreciate you working with us and the other stakeholders, and certainly anything that is changed, if it in any way harms supervisees' ability to get supervisors or anything that could potentially harm access to care for patients. Certainly we would want to address that and make sure that didn't happen. But again, we just appreciate working with us to help clarify, just so we can clarify for our members. Thank you.
Thank you.
And I do not see any other requests for comment. Shall I close the public comment feature?
Yes, thank you.
You're welcome.
All right. Then that agenda item is concluded. Yes, because we're not moving with the.
So no, what I would do is I will draft for the language in both attachments A and B for the other 2 license types that are affected. And also I will draft the second scenario in C2, and we can discuss further as well. And stakeholders will have some more time until November to think about how they feel about it.
All right. Thank you so much, Roseanne. I appreciate all the hard work on this. We are at 2:30. There's only a few more items left. Do we need a 5-minute break, or are we okay to push through? You're good? You're good to push through? Okay. Then let's move right along. Next is Next is item 29 on the agenda, update on board-sponsored and board-monitored legislation. Roseanne?
Yes, so the legislative session for the year is actually winding down. September 14th is the last day for each house to pass bills. And then the governor, once the bills that make it to his desk, he must make a decision on whether or not to sign them by October 14th. So by the November board meeting, we'll have an answer on whether the bills that are listed in here that are still moving have been signed into law or not. So we're getting winding down. Our particular bill that the board is running this year, AB 232, the temporary practice allowance bill, that bill is actually going to be heard in the Senate Appropriations Committee this coming Monday. And that's the last committee that it goes to before it goes to the full Senate floor and then hopefully the governor. SB 887, which is the board's omnibus bill, has passed all of its committees and is onto the assembly floor for a final vote. And then you can kind of see the status of some other bills that the board has taken positions on or reconsidered positions on today. There's a lot that's still moving. There's some like 525 that we're still expecting amendments on that we haven't seen any amendments happen yet. A lot of bills are in appropriations committee, so we'll see if they make it. The ones that have big fiscal impacts, the legislature has to decide whether or not they make it out of the appropriations committee. So it's an interesting time of year and we'll have some answers soon. So that's all I've got.
Okay, excellent. Any comments or questions from the board? Nope. Sorry, I can't see with my glasses on. No, I can't. If I wear the glasses, I can't see in front of me. But if I don't have them on, I can't see my computer. Any comments or questions from the audience? How about from our online audience?
This is the moderator. If there are any comments on the presentation, you can look for the hand icon and click that to raise your hand. You can look for the question mark icon, click that, type the word comment in the text box and click send. And our call-in users may press *3 to comment to raise their hand. Are there any comments on this discussion? I do not see any requests for comment. Shall I close the public comment feature?
Yes, thank you, moderator.
You're welcome.
All right, and next on the agenda, item number 30, update on board rulemaking proposals. Christy?
Yes, hi. We don't have anything to report. This is usually for rulemaking packages that are in process. So the next time, because the board just approved those will be in the report.
Perfect, thank you. All right, and then our next item is suggestions for future agenda items. Are there any future agenda item suggestions from our board members? Dr. Walker.
Yeah, just a thought here. I'm not quite sure what the correct protocol or name for this would be, but in regards to when we have staff present to the board, like today we don't have a full board and everyone's fortunate to sit up here at the dais and we're all fitting in nicely. But there are times when it's not. Like I know it's been a little awkward for Susan to try to read the screen when she doesn't have one in front of her. We can't provide one. And so I'm just looking at how we might work more streamlined and more efficient, and maybe having presentations before the board, if they're for the board, if they could present here, or just something for us to look at. And another thing, we have made public comments timed. I don't know if there's a protocol for board members. Like I was speaking today and I went a little long and, I didn't intend to, but it would have been nice for me to know, okay, you have 30 seconds to go. Maybe I should be limited to 3 minutes or 2 minutes of comments, and then I know when to respectfully stop. But is that something in place for this board? Again, I'm somewhat new and I don't know what that protocol is.
Well, I think we can definitely, I can talk with Chris about that and stuff too. That's a protocol where we try to, with, looking at the agenda and stuff, it's really the kind of the coordination with me and the board president or whoever to try to move it along. But yeah, no, I think we got your suggestions that were, yeah. we
Okay,
can still do that.
appreciate it.
And
Thank
I
you.
like the suggestion of if we do, if comes a time where we think we need to speed it along, is offering to the board members to,
Yeah.
15 seconds, let's wrap it up. So.
And I need to work on that as being the manager of the board too. So I apologize. I didn't mean to cut you off earlier, Dr. Walker.
Thank you, Mr. Chair. Appreciate it.
Susan.
I would like to see that we have a discussion about how we can think about getting more people to become therapists. I know we've talked about getting the legislature to give money for attracting certain young people to go to school. We've talked about that. But I mean, I think that it's really a major discussion that we should have because it is timely right now with all the people who need therapy and no therapists around. I mean, I know from my work on the county mental health board that there is more than an 8-week waiting period to even get your name on a list. I mean, how good is that for people who are suffering from depression and anxiety?
Thank you, Susan. I believe that our bill, the mental health counseling bill for the CSU is a step in increasing the pipeline, but we can add how can we support increasing the pipeline for therapists into future agenda items. So thank you. Anyone else? Our audience?
Hello, John DeLine, MFT student. I kind of talked about this earlier about suspending the licensing exam. I feel like as California is trying to decide whether or not to take the national exam, and because we are in a place of crisis for more therapists, it might be good to discuss like suspending it for a year, like what happened in Illinois with the bachelor level social workers when they took away that licensing exams. They were flooded with a whole bunch of people who were stuck trying to get that licensing exam, and seeing if that is a way of a stopgap measure right now that we could actually kind of flood the market with more therapists who have done 3,000 hours, which I would argue personally seems like a lot of practice to be able to help people in therapy. And the other thing that I would love to talk about eventually is how can mental health professionals and the profession of mental health be integrated into public safety and public protection officers. Like with a program like Cahoots in Eugene, or the programs that are going on in San Diego and Los Angeles at the moment. Thank you.
Thank you. All right, and from our online audience, any future future agenda item suggestions?
If anyone would like to suggest a future agenda item, you may look for the hand icon, click that to raise your hand. You may look for the question mark icon, click that, type the word comment and click send. And our call-in users may press *3 on their phone to raise their hand. We do have a question or a topic from Jerry Grossman. Jerry, I'm going to send you a request to unmute your microphone so you may ask your question. You'll have 2 minutes with a 15-second warning. You're unmuted.
Hello?
Yes.
Oh, great. Okay. Wonderful board meeting. And my question is regarding the informational brochures regarding telehealth. I know in the future there's been discussion about having 3 brochures going out, and I was just wondering if there's a timeline for that.
This is future agenda items, Jerry, and they are out.
Oh, they are out and they're
Yes,
just on
they
the
are.
board's website? Great. Thank you.
Very welcome.
And I do not see any further requests for comment at this time. Shall I close the public comment feature?
Yes, thank you.
You're welcome.
All right, next item on the agenda is public comment for items that are not on the agenda. So I will ask for public comments for items not on the agenda. As a reminder, the board may not discuss or take action on any matter raised during this public comment section, except to decide whether to place the matter on the agenda of a future meeting. Each commentator will have 2 minutes. Do any of our board members have any comments for items that are not on the agenda? Sorry, I can't see. There we go. All right. No, excellent. Our audience?
Hi, John, MFT student, and I just wanted to say you guys are awesome. Thanks.
Thank you, John. Appreciate that. Hope that's duly noted in the record. Excellent. Thank you. And how about from our online audience?
If anyone would like to bring up a topic that was not on the agenda, you may click the hand icon to raise your hand. You may click the question mark icon, type the word comment and click send. And our call-in users may press *3 to raise their hand. Any items that were not on the agenda? I do not see any requests for comment. Shall I close that feature?
Yes, thank you, moderator.
You're welcome.
And our final agenda item is adjournment. Thank you for participating today. I hope that to see all of you at our next board meeting that we will be held on November 16th and 17th, 2023. Meeting adjourned.